of appearing here with the rest of the court to do arguments. This is one of the fun things we do when we do our work. We get together once a month during a particular week to hear oral arguments. Otherwise, we are actually spread out around the state where our chambers are. We have the legislators in this matter to thank for inviting us here this morning, as well as, and I've extended previously the thanks to all the people who were able to make this happen. I'm not going to repeat that here this morning. But thank you also to the attorneys, Maureen Sturtevant and James Spitzuko, who are here and who are assisting in helping us explain to you what we do here today. These aren't trials. We don't hear trials when we're on the Supreme Judicial Court. We hear appeals, and that means there's already been a trial or other kind of disposition in the trial court. And our purpose is to determine whether or not there was any kind of error made in the lower court. We're always very excited to be able to go out to the high school so that you can see up close and personal, if you will, the workings of the judicial branch. All of you know from your basic civics that there are 3 branches of government. And we see the executive, the governor, on a pretty regular basis on TV. You hear about the legislature passing laws on a pretty regular basis on TV, but you don't usually see us too often. So we are very happy to be able to be here. People hear about the U.S. Supreme Court, but you know what? 98% of cases in this country are heard in state courts. That's us. So we always like to think that this is where the action is, because it really is where the action is. As I say, I'm the Chief Justice of this court. We always sit, we're very tradition-laden. We sit and enter and do everything in order of seniority. And by seniority, we mean longest tenure on this court, except I get an exception as chief. I just am automatically considered most senior, although obviously not. But we talk about seniority as being our length of service on this court. So I'm going to ask my other colleagues to introduce themselves. My chambers are in Augusta. They're going to tell you about themselves a little bit, starting again with our most junior justice at this end.
Good morning. My name is Wayne Douglas. It's a pleasure to be here. Thank you for having us. I've been a judge for a little over 20 years. I've served on the trial courts for most of that time. I've been on this court for about a year and a half. My chambers are here in Portland.
Good morning, I'm Rick Lawrence, and I am very grateful for having the invitation to be here today, and happy that you're all here, and hopefully that it's an entertaining session for you. I've been on the court for 24 years, 22 of that spent on the district court in the state, and joined this court in May of 2022.
I'm Catherine Connors. I've been on the court since February 2020, and this is the only court I've ever been on, and my chambers are in Portland.
Good morning, everyone. Thank you for inviting us here. My name is Andrew Horton. I have been a trial judge for 20 years, beginning in 1999 and ending in February of 2020. Justice Connors and I came on this court together.
Usually there's a bit of a dispute about which of you is really senior.
Yes, she was sworn in 15 minutes before I was.
Before, go on.
But I'm considered senior because I served as a trial judge for 20 years before I became on this court.
Lawyers.
And I'm fine with that, but not everybody else is. In any event, my chambers are in Portland as well.
Good morning. My name is Andrew Mead. My chambers are based in Bangor, although the court holds forth in Portland and Augusta and occasionally in Bangor. I've been a judge for 34 years, the last 18 on this court, the Supreme Judicial Court, sitting as we are today as the law court. It's a pleasure and a privilege to be here today, and I hope you find our session enlightening.
And with that, then, I will call the first case, which is State of Maine versus Jarae Lipscombe. and this is Kennebec 23455. Council, I believe, are ready. I should warn you, we really can't see you very well. We kind of have the lights in our eyes. But if you would introduce yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good morning, Rory McNamara for the appellant, Jarae Lipscombe.
Good morning, Michael Madigan for the state of Maine, the appellee.
Thank you. And Mr. McNamara, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, Counselor. Jarae Lipscombe has never known of conduct by his brother.
Counsel, I see that you have graciously let the green light come on right
Yes.
away. If this evidence, in this case, for a prosecution of hindering apprehension, if the evidence of what happened at his brother's trial is admissible on a motion for a new trial, aren't we then simply reinstating the rule that it will be dependent either way on what happens with the trial of the principal?
No, it's not dependent in either way. So at common law, and for quite a while, there was a tradition whereby the hinderer, if you will, could not be convicted for hindering if the principal was acquitted, was not guilty of that. So necessarily in those days, the hinderer's trial had to follow the principal's trial. My argument is not that there is some sort of immunity here. It is simply that that evidence, be it a conviction of the principal, or here we have an acquittal, is relevant evidence.
Correct, but if it's relevant, and if we grant a motion for a new, oh, the lights just came up a bit. Grant a motion for a new trial,
see.
don't we then have to either wait for the prosecution of the principal to occur in every case, or grant a motion for a new trial in every case?
Well, I think it is up to the state when they try, I mean, to a large degree, up to the state and to the courts
That
and
would
to
be news to
wisdom.
the trial judges, but.
And to trial judges and dockets, and to the wisdom of the court as to when to hold those trials. And I do think it makes more sense, given the possibility of a motion for a new trial coming in circumstances like this.
Could we just back up for a second to the facts here, just so we can put it all in perspective? Your client here has a brother,
Right.
and a brother was charged with murder. And the evidence was that I guess they saw someone on a video camera, and your client was aware to some degree that his brother was involved in something around the circumstances here that led him to be charged with murder. So they charge him with murder, and they charge your client with hindering apprehension because a police officer said to him, "You saw a guy walking out? Yeah, what do you look like?" And he gave a description that was not at all like his brother. Maybe he's trying to help his brother out by sending the police in the wrong direction. We don't know. So what happens is the brother goes to trial, and he's found not guilty.
Right.
Now, you're not saying to us that because the brother got found not guilty of murder, that your client can't still be charged with hindering.
Correct.
You're, just to make it clear, in 2 sentences or less, can you tell us what you're asking us to conclude and rule here?
The issue of law is whether or not it is relevant evidence at my client's trial for hindering that his brother was acquitted.
So you want the jury to hear, the hindering trial is going on, and you want the evidence to go to the jury and say, well, the guy that actually committed this crime, he was found not guilty. And what inference would you have them draw from that?
I think they can draw two, and maybe they are sides of the same coin, different sides of the same coin. One is that tends to prove that, in fact, the brother did not commit the murder, and
But
the
whether
other...
the brother committed the murder is not an element of the charge of hindering.
No, but I think it tends to support the fact that the brother, my client, is correct in his assertions that he doesn't know of conduct constituting murder.
Why? Let me read a little part of Weinstein's evidence. It says, judgments of acquittal are almost always excluded because of a lack of relevancy since they do not necessarily prove innocence, but may indicate only that the prosecution failed to meet its burden of proof beyond a reasonable doubt as to at least one element of that crime. And it says, goes on to say, acquittals establish only that the jury is not convinced beyond a reasonable doubt that the material propositions of fact have been established, or that the jury is exercising its inherent mercy dispensing power. So the defendant cannot claim to the contrary of the material prosecutions of fact have been found as a result of the judgment.
Your Honor, the standard for relevancy, as you know, is a very low bar. It's been described by this court as a very low bar. And I think what Mr. Weinstein was saying there is that it may not prove a lot. But that is up to a fact finder to determine. We're here talking about relevancy.
Does it prove anything with respect to the hindering apprehension charge? Because there, it's simply a question of at least one part of that offense is that your client in this circumstance would have been aware of the conduct that resulted in the person being charged with the offense, not convicted, charged.
That constitutes murder. That constitutes murder. And I think my client was saying that it was an unidentified blackmailer. He didn't know who committed this crime. And that is the other side of the coin of what this tends to show. If after a trial, hearing all the evidence that can be marshaled against the brother, a reasonable jurist found that the brother is not guilty beyond a reasonable doubt, that is something that I think anybody would want admitted at their trial for hindering.
So, counsel, what evidence are you specifically proposing to introduce?
The docket record. The docket record or a statement.
The document itself.
Correct, or a statement from somebody with familiarity of the docket record, that there's an acquittal.
You argue in your brief that if that's not permitted, it's going to be catastrophic, basically, for the state in any other kind of case. I'd like to take issue with that.
Okay.
But before I do, the statute itself says, knew of the conduct that the other person has in fact rendered the other person liable to such a charge.
Correct.
Whether or not a judgment of acquittal, a judgment of conviction that shows acquittal or conviction is introduced is irrelevant to this charge. The statute says liable to a charge.
And I understand what you're driving at, but I think it's very important that as a judicial system we have faith in our judgments. And of course our judgments, be they criminal, civil, or otherwise, represent to us whether or not the conduct underlying those judgments is true or not.
But there's a danger here. If the jury gets the judgment of acquittal, remember the jury, here's the judgment of acquittal, brother is found not guilty, they'll say, okay, what does that mean? Does that mean that he didn't do it? Did it mean that some legal technicality got him off? Does it mean that there was a terrible decision by a judge or a jury? Does it mean that the state pulled back? They won't know the backstory. They won't know the evidence that went in at the trial. And so what does that document tell them?
It tells us the same, that when the state, and this goes to Your Honor's point, you'd like to get into this, and so we'll try to tie these two together. The value of a conviction, which would universally be offered in a case like this, and in cases otherwise where there is a principal accessory, there are co-defendants, is that conduct has been established. And you're right, Your Honor, there could always be doubts, oh, maybe the principal was convicted because he had a bad lawyer.
Yeah, but
maybe the police
issue
missed
here
some.
is really more whether he knew of the conduct that resulted in the charge.
Correct.
I mean, there's no question that his Jarae's brother was in fact charged with murder, right?
Right, but
You're saying that's what we're arguing about because he
Right.
was acquitted of
course.
it. So the question here is whether Jarae knew of the conduct that resulted in that charge at the time.
Right.
On the scene,
Right.
when he gave misinformation that was essentially led to the charge of hindering. And how does what happens afterwards in a court go to the issue of whether he knew of the conduct that at the time that resulted in the charge?
Jarae's, my client's defense at trial was that he simply did not know of conduct by his brother
Right.
constituting murder, and that in fact he knew that an unknown black male had committed that murder.
But the state's last witness testified that Jarae Lipscombe told her that his brother had shot somebody.
Yeah, I think there was evidence to prove the otherwise. However, there was a lot of question at trial about
Right,
the
but how
credibility
does-
of that witness.
But how does the later acquittal of his brother, which just simply means, as we all know, that the state did not prove the case to the judge's satisfaction
Right.
beyond a reasonable doubt, doesn't mean he didn't do it, that's what it means.
Because the defense lawyer...
But how does that go to whether or not at the time of the events, Jarae knew of the conduct that led to the charge?
Because his brother has been acquitted of murder,
But
so
he
of
doesn't
course...
need- But he doesn't need to know the legal consequences
No,
of the
he-
conduct.
no,
He
he
just
doesn't.
needs to know the facts.
Correct.
Let
Just,
let me give you a hypothetical. I'm into hypotheticals today. Here's a hypothetical. A guy knows that his brother is at a particular house. He knows that a shooting took place there. He knows that his brother owns a gun. And the police come to him and say, you know, you saw the guy leaving? Yep, I saw the guy. Yeah, he was about 7'4", kind of Nordic build, and his brother's 5'7" or something like that. And the police start looking for some 7'4" Nordic kind of guy, and meanwhile his brother is not the subject of any of the attention. They eventually charge his brother. Brother's acquitted. Hasn't he still committed the offense of hindering apprehension?
no, not if he didn't know. Not if he didn't know of the conduct by the 7'4" Norseman who committed the
He
crime.
knows that there was a shooting there, and his brother owns a gun, and his brother was seen, he knew his brother left the scene.
All I'm arguing, and all that's been argued by the state, is that this fact, that the brother is not guilty, is probative. It's probative because
Well,
it tends to
Let me
prove.
say then, don't you have a problem with the standard of review here? Because not only does it have to be really good evidence because of the posture after judgment, but also the judge here at the trial said, I don't think it's relevant. And don't we give trial judges a lot of room to decide what's relevant and not? So should we treat the judge's ruling in the post-judgment context, saying, I don't think it's relevant, like we treat other relevancy determinations?
No, I don't. I think because this case does carry with it some important consequences. If a judgment is not relevant towards whether someone committed the conduct underlying a judgment, we are saying, number one, a fundamental thing about our judgments in this system, but number two, we're also preventing the state from offering, as a matter of what's good for the goose, what's good for the gander, convictions and evidence of convictions, both to prove knowledge and to prove that another individual committed the principal crime. Thank you.
Thank you. Mr. Madigan?
Good morning. May it please the court. My name is Michael Madigan. I do represent the state of Maine, the appellee in this matter. Justice Stokes got this
Well,
matter.
the light is on, so let me ask about the last comment said by the counselor there. If we say acquittals aren't relevant, does it follow that convictions aren't relevant either?
Absolutely not. This is a very specific issue. Every determination of relevance is specific, fact-specific to the case, the charge, the elements of the charge, the evidence that's going to be presented. This case is no more controlling for all future cases than...
So your position would be that although evidence after the fact or evidence that his brother was acquitted is not relevant, had he been convicted, it would be relevant?
No, Your Honor, I'm not going to say that. I disagree. I don't believe that the verdict in the brother's case, guilty or not guilty, is relevant to the appellant's case.
Let me follow up on that, counsel. If the trials had proceeded in reverse order and the brother was convicted, would you be offering in Jarae's trial evidence of the conviction of his brother?
I don't believe that a court, putting myself in the posture of the trial attorney, I don't believe that a court...
Probably would try.
I don't necessarily agree, Judge. I don't know that again, the state cannot have it both ways, nor should we try to have it both ways.
But isn't that, are you backing off too far? I mean, if there is the fact of a conviction, that means that a jury found beyond a reasonable doubt that the other person committed the crime, which is a fact, as compared to a judgment of acquittal, which simply means the state didn't meet its burden. Aren't those two fundamentally different things? One is these facts have been established.
They are, but when we look at verdicts, as your honors have previously mentioned, the verdict is not necessarily a finding of fact. It's an overall determination. It's the ultimate determination by a fact finder as to whether or not the state has met its burden in meeting all the elements.
Okay,
But
all
it doesn't go into the details of what facts the jury found, gave weight to, gave credibility to.
All right, if you're saying no verdicts go in either way, then we'll just leave it at that.
Well, we have to look at the statute that it's at issue here. The hindering statute does not address that fact, and that has historically been developed. And we know that many years ago, when you had accessory after the fact, it did matter.
So as we all know, when you prove a case, there are elements of the offense. You have a checklist, no doubt, when you're working. And your checklist on a hindering doesn't include prove that the other person was convicted.
It is not an element of the crime, and I believe it would be misleading. And I-
Does it
You agree
include the
that the
indictment?
acquittal,
Does it include the indictment? Would you
the
be putting
brothers-
in, you have to put in some proof of a charge, correct?
No. Well, if we use the language charge, I'll disagree. We do not need to prove that the person was charged. We could, or in the alternative, was liable to be charged. And I might be misstating that one a little bit, but
you agree that the brothers' acquittal calls into question whether there was a basis for the murder charge in the first place?
no, not at all.
So you don't agree that the acquittal calls for a revisitation of the conduct of the brother that resulted in the charge and that the defendant here, Mr. Lipscombe, was aware of?
I do not, Judge, because when we look at the two cases, the fact pattern is relatively similar as to what evidence would have been presented for both. And I'm speaking obviously removed from the actual trials specifically, but the entire circumstance and patterns would have been similar in both cases.
The
So
acquittal suggests that the brother wasn't liable for the charge, right?
under the hindering statute, no, the acquittal does not. At the time, under the knowledge and information known to the appellant at the time, the state's evidence was sufficient to convince a jury that the brother knew that the appellant would know that his brother was liable for the charges.
It's also
Whether he was charged or not,
It's also an entirely different standard. I mean, the jury's assessing this, looking at the evidence to prove beyond a reasonable doubt as opposed to a charge, which can be based on simply probable cause. So they're apples and oranges.
and a jury instruction, and this is part of the hypothetical, if we were able to determine that this acquittal was relevant to the hindering charge, we would also be determining that a conviction would be relevant. We would make multiple determinations as to relevancy.
What
But
is,
then-
do you care to opine on what the purpose of this statute is? What evil did the legislature have in mind when they created the charge of hindering apprehension? What were they trying to prevent or prohibit?
People from misdirecting law enforcement and investigating crimes by failing to relay the information or lying, more importantly. Obviously, everybody has the right to not talk to the police. But when you actually misdirect, lie, or harbor, conceal, prevent people from stopping investigations.
In the state's position is that's what took place here.
Exactly. It led to a misleading of law enforcement. Law enforcement was misled for a period of time. That affects the investigation, affects the ability to identify witnesses, to collect evidence, to make timely observations. Relatively significant, especially in Maine, we have there's nothing more serious than a murder, and that is exactly what was being investigated.
Is that what happened here? Was the officer misdirected in the wrong direction and not seeking the right person?
That's my understanding because of the information that was originally relayed to them. And whenever a murder happens, depending upon the jurisdiction in which it happens, you always will have multiple agencies involved, all trying to work together and coordinate and follow leads. So it can create significant delays in an investigation and potentially In this case, it did not, but it potentially could lead to individuals essentially getting away with murder. And
Is the
that's why this
judgment
was
of
brought.
acquittal hearsay?
It's an interesting question. I believe that it could be argued as hearsay, but given that we do accept certified records and records of convictions may be admitted under the hearsay exceptions, I believe that a court's judgment or docket record or any number of court documents may be admitted under multiple exceptions.
So does the mischief in admitting it really lie in the fact that we don't know what an acquittal actually means?
That is a very large part. It would be extraordinarily, so again, if we go back and say that we are going to find this as relevant, I think we then move to the 403 analysis.
I was going to say, is that really a 403 analysis? And by that, we mean that even if it has some minimal relevance, it has a tendency to be so confusing in terms of what it means or how we argue it, that you would then be retrying, well, it wasn't because he was innocent, it's because, and there was plenty of evidence and all the other things that go into that.
All of that, and then ultimately to look at a jury, and the instruction would have to, the judge's instruction would have to be, you've received evidence of a verdict, but you may not consider that verdict, which is going to leave the jury at an absolute loss as to what to do, and essentially negating. So again, should this matter end up in a new trial, should this evidence be brought in, there would have to be some jury instruction as to what that verdict, not guilty, and to follow the hypotheticals, even if it was a guilty verdict, the instruction would have to be, you have to disregard that verdict for what it is.
Attorney McNamara is probably going to say, he's probably thinking about this right now, but he's probably going to say something like, the instruction would be, members of the jury, you received a copy of a judgment of acquittal. You may consider it only for the purpose of whether or not the defendant here knew of the conduct of the person charged him. That's probably what he's going to say, that he would cabinet to that.
Well, and again, we're taking it out of the jury's hands. We're saying here is a judgment of acquittal, a judgment, a verdict in a trial, but you have to decide for yourself. We're telling the jury that that issue that the state has the burden of proving has already been decided, and it has not been decided. Evidence had to have been submitted as to the knowledge of the appellant during the course of the trial, sufficient for that jury to come to the determination of guilt beyond a reasonable doubt.
The key here in some ways, isn't it, that the evidence necessary to support a criminal charge, meaning probable cause, is different than the evidence necessary to support a conviction. And the statute, the hindering statute, refers simply to conduct resulting in the charge, not conduct resulting in the conviction.
Exactly, and that's the burden that the state has at trial, to introduce the verdict that happened, again, 2 years after the fact. And even if it's on a far stretch, we're simply introducing this verdict to bolster the defendant's testimony. He said he didn't know, and this verdict said the brother wasn't guilty. Now we'll take it to the next step, and we have to look into, are we going to do a 303 analysis? What does that mean? As the Chief Justice pointed out, do we dive into the verdict? We don't dive into verdicts. We're not going to pull the trial judge.
303, did you mean 403?
No, I might have. No, I'm moving to 606. Sorry, 303, 606.
So I'm sitting there going, what's a 303?
I knew I had a number, zero, same number. 606 analysis as to what the verdict means. In verdicts, we do not do findings of fact. So we don't know. Did the actual brother's trial justice find certain facts, but those facts alone were not sufficient to meet beyond a reasonable doubt for murder? So it's that, for lack of a better word, the boulder rolling downhill is simply just going to get bigger and bigger and bigger under that 403 analysis.
Counsel, can I refocus this just slightly?
Please.
The trial judge concluded that there was no newly discovered evidence. Because it was not relevant, but it is evidence, isn't it? And if it is, then don't we assess it under the standard under Rule 33? One of the elements is materiality. So in that sense, the trial judge is correct, but it is evidence. Right?
And it's actually an interesting question, Your Honor, and Under Justice Stokes' determination based on it's not newly discovered evidence because it's not relevant, therefore not admissible, is it some new information? Yes.
But is it, evidence is defined as something that will prove something is more likely than not. And we just said it has no relevance, in which case it's not, if you assume that it has no relevance, then it's not evidence, right?
And yes, we use the phrase newly discovered evidence, and I think it should be parsed out better. It's new information, but is that information evidence?
But it's
In
got
this
to be
case,
probative of the whether the person should have been held guilty. And if it's not probative, then it's maybe it's semantic, but then it would, if it's not probative, it's not evidence within the meaning in that context.
And I think when we look at Justice Stokes' determination, it really does come down to semantics, in that he's saying because it is not relevant, that information, that verdict is not relevant, meaning it will not meet the 401 definition nor survive a 403 balancing. Therefore, it's not newly discovered evidence. I don't think he didn't parse it out to say it's evidence or it's newly discovered, it's information. Does this information rise to the level of becoming evidence? And evidence is a very technical term for information that is admissible in a trial in order to help the fact finder reach their conclusion. But I think it really is just a semantics in that we're not going to sit here and say it's not newly discovered. The state's not going to say that it's not information. But the state's position is that that information does not rise to meet the definition of relevant evidence. There's no further questions.
There do not appear to be, Mr. Madigan. Thank you.
Thank you.
Mr. McNamara, can I go to where we are procedurally in this case? In other words, this is on a motion for a new trial. And haven't we said, putting aside the issue of whether this is evidence, et cetera, for a motion for new trial on the basis of newly discovered evidence, we have said that it has to be evidence is such as will probably change the result if a new trial is granted. A mere possibility is not enough. That therefore, it seems to me that if evidence, even if it has some marginal relevance as you're positing, that we then review the trial judge's decision to deny the motion for new trial for clear error. Can we really say, given all that we've discussed here today, that the admission of a piece of evidence of the acquittal is such as will probably, not just possibly, but probably change the result of Jarae's trial?
Yes, and I think the best evidence of that is that the state has never argued that this is evidence that would not probably change that outcome of the trial. The trial court, who of course very experienced former prosecutor who presided at many trials, did not find that this would not probably change the outcome.
Well, isn't that really what you're finding when you say it's really not relevant?
No, I think that's a technical reading of 401. But to keep going with the reasons, back to the trial, the judge almost sustained a Rule 29 motion because there was very little evidence that my client knew of conduct constituting murder by his brother. It was very close to doing so. And the prosecutor, in fact, said in plain language, yeah, we didn't really prove that element beyond a reasonable doubt. The motion was still denied. That is something that defense counsel argued to the jury, and it is also something that I think is potentially really powerful to a jury. If a skilled defense attorney gets up to the jury, who is not six of the most experienced jurists we have in the state, usually, most often, and can sometimes be persuaded by logical arguments.
If you're successful in doing this, in other words, if the judgment comes before the jury with an instruction, if there's some explanation as to why the acquittal occurred, can the state offer evidence to say, yeah, he was acquitted on this because our main witness died and we weren't able to put on all our evidence?
I think there is a
little trial within a trial going on there?
So I think that's at some point there's a 403 objection to where that stops. But that whole parade of horribles, the mischief in admitting it, as Your Honor put it, is also applicable to when there's evidence of a conviction. Again, I said bad lawyering, to fact that witnesses don't always come forward in the same manner to aid the defense. That we could get into that whole can of worms, and I challenge this court, if we are going to say that this evidence is not relevant, to write this opinion in a manner that makes it clear that we are on equal footing. Convictions and acquittals are simply not relevant. Thank you.
Thank you, counsel. And thanks to both of you for your arguments here this morning. To the students who are here, you may be disappointed to know that we don't render our decision today. We will, as is our usual practice, take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.